Hi folks, welcome to SQE1 window. In our chapter 3 of land law, we look at legal and equitable co-ownership, trusts of land. Trust law and equity is closely linked with the land law, and we got a concept of trust of land, and that is co-ownership and joint ownership, and these concepts are most of the time tested in SQE. So what is co-ownership? Like ownership of land arises when two or more persons simultaneously own an estate in land. And now we are talking about estate, not in trust, freehold and leasehold. This might sound straightforward, but it creates significant legal complexity that requires full analysis. Co-ownership is extraordinarily prevalent, like in modern society. Think about married couples purchasing a home together, consider business partners, acquiring commercial premise, and imagine siblings inheriting property from their parents. In all these situations, multiple people have ownership rights in same piece of land. What makes co-ownership particularly complex is that most co-ownership operates through trust of land. This creates a fundamental separation between legal title and beneficial ownership. The people whose name appear on the register may not be the only people with the rights in the property, and their legal interest may differ from their economic interest. So understanding this separation is absolutely essential. It determines who can deal with the property, who benefits from it, and what happens when dispute arises. Crucially, for convincing whether purchasers take free of beneficial interest or remain bound by them. So all of it is something that we need to understand regarding co-ownership. So what is legal versus beneficial ownership? There are two different things. So we examine fundamental split in ownership carefully, because it's the key to understanding everything that follows. Legal title is what appears on land register. It's held by registered proprietors. Legal title is always limited to a maximum of 4 owners, and crucially, it's always held as a joint tenancy. This is a rigid rule with no exceptions, not more than 4 people on the title register. The legal title holder are the trustees who have the power to deal with the property. Beneficial ownership reflects who truly benefits from the land. It appears the economic interest who has the right to live in the property, who receives the proceeds if it's sold. Beneficial ownership does not appear on register. There is no limit on the number of beneficiaries, but legal, 4 people like that as joint tenants at that point. And importantly, beneficial interest may be held either as a joint tenancy or as tenancy in common. So co-ownership is joint tenancy and tenancy in common. Both of them are 2 different things. We will try to understand that as well. So the critical point, legal and beneficial owners may differ. The trustees who hold legal title may hold it entirely for themselves, or partly for themselves and partly for others, or entirely for third parties. So this separation allows complex ownership arrangement. A husband and a wife might be the legal owners, but they might hold the property partly for themselves and partly for relatives, or a relative who contributed to the purchase. Understanding who holds that and in what capacity is fundamental to analyzing co-ownership. Once again, co-ownership, it can be joint tenancy and tenancy in common. On legal title, 4 people, and they can hold it for 100 people at that point. Legal title and then beneficial ownership, that's what you should keep in mind. So let's make this concrete with a practical example. Take a simple family scenario. A married couple purchased a home. Both names appear on the legal title as registered proprietors. They are the trustees. They hold the legal title on trust for themselves as beneficiaries. In their capacity as trustees, they manage the property and have power to sell or mortgage it. In their capacity as beneficiaries, they enjoy living in it and benefit from any increase in its value. This seems like unnecessary complication when the same people are both trustees and beneficiaries, Why not just say they own the property? The answer is that trust structure provides essential flexibility and protection. First, it allows for contribution from people whose name does not appear on the legal title. If a parent helps with deposit, they might acquire a beneficial interest while remaining off the legal title. Second, it protects against creditors. If one of co-owner becomes bankrupt, the trustee in bankruptcy cannot simply sell the property without going through the proper procedures at that point. Third, it ensures that property transaction can proceed efficiently through the mechanism of overrating, which we shall explore. So this separation of roles is fundamental to understanding co-ownership in English land law. So why co-ownership? The automatic trust rule we will try to explore here. So something that surprises many of us: whenever land is held by joint proprietors, they automatically hold the legal estate on trust. This happens by operation of law. You don't need express words creating a trust. A trust arises automatically the moment there is co-ownership. Why does this matter? Because it means co-ownership always involves trust law, even when the parties haven't thought about trust at all. There is an important practical consequence. Legal title is limited to a maximum of 4 trustees. This is imposed by Section 34 of the Law of Property Act 1925. If a conveyance purports to transfer legal title to more than 4 people, only the first 4 named take the legal estate as trustees. But beneficial interests face no such limit. You could, at that point, you could have 10 beneficiaries or 20 or more. They all hold beneficial interest, but only up to 4 can hold the legal title as trustees. This limitation serves a practical purpose. Purchasers need to know they can obtain a good receipt by paying to the trustees. The 4 trustee rule simplifies conveyancing while still allows unlimited beneficial ownership. So the next thing is, we got a law, and that is Trust of Land and Appointment of Trustees Act 1996. We need to understand about it. So universally it is known like Tollata. So that governs trust of land in modern English law. This statute fundamentally reforms by the law and applies all trust created after 1996, as well as retrospectively to the earlier trust for sale. Section 1 defines a trust of land simply as any trust of property while consists of or includes land. This broad definition captures all forms of co-ownership. In 1996 Act, it made a fundamental shift. Under the old law, trustees held land on trust for sale. They had a duty to sell. Under this law, this abolished it. Trustees now have a power to sell rather than a duty to sell. So this is not a duty, this is a power. This aligns the law with reality. Most co-owners want to retain and use the property, not sell it. This legislative framework provides trustees with flexibility in managing trust property. They can retain land indefinitely if they serve the beneficiaries' interest. They can sell if circumstances require. The power exists, but there is no obligation to exercise it. That's what you need to keep in mind for your SQE1 exam. So section 6 to 9 we will try to cover here. Section 6 of the Tollata, or this trust law, gives trustees of land the power of an absolute owner. This is an extraordinarily broad grant of authority. Trustees can sell the trust property, they can lease it to the tenants, they can mortgage it to raise capital, they can purchase additional land, they can partition the property, they can delegate many management functions, though not their core duties. This broad statutory power enables trustees to manage trust property effectively and respond to changing circumstances. But these powers come with essential constraints. First, trustees owe fiduciary duties. They must act in best interest of all beneficiaries. Second, all trustees must act unanimously. If there are three trustees, all three must agree before exercising any power. A dissenting trustee can block action. Third, when property is sold, the proceeds must be distributed according to the beneficiaries' beneficial shares. So these constraints ensure that while trustees have broad powers, they exercise them properly. The beneficiaries in trust are protected by these duties and by the requirement of unanimous action. Understanding this balance is essential for analyzing problem questions where trustees' action are challenged. So, rights of beneficiaries, occupation, consultation, and control. While trustees have management powers, beneficiaries have important rights that balance those powers. Section 12 of Tolata grants beneficiaries a right to occupy trust property. But this right is not absolute. It applies only where the purpose of the trust include making the property available for occupation and where the property is suitable for occupation by the particular beneficiary. This means beneficiaries don't automatically have right to occupy all trust property. If land is held purely as an investment, Section 12 won't give beneficiaries a right to move in. Section 13 gives trustees power to regulate occupation. They can restrict or exclude a beneficiary's occupation where they have good reason. They can impose reasonable conditions, such as requiring the occupying beneficiary to pay outgoing. They can require compensation to excluded beneficiaries, ensuring fair treatment for everyone. Beyond occupation rights, trustees have duties to consult beneficiaries of full age and as far as consistent with the general interest of the trust, to give effect to their wishes. Section 19 allows beneficiaries in certain circumstances to exercise powers to appoint new trustees or remove existing trustees. These provisions create a balance. Trustees have management powers, but beneficiaries have occupation rights and consultation rights. So this is a good balance between both trustees and beneficiaries. So how to resolve disputes? Co-ownership frequently generates dispute. One co-owner wants to sell, another want to stay. Creditors seek to force sale to recover debts. How does the law resolve these conflicts? Section 14 of Tolata provides a comprehensive dispute resolution mechanism. It allows any trustees, any beneficiary, or any person with an interest in property to apply to court. The court has extremely broad powers. It can make any order relating to the exercise of trustees' functions. This might include order of sale, orders regulating occupation, or orders appointing new trustees in. When deciding application, the court must consider the factors listed in Section 15. These include the intention of the person who created the trust, the purpose for which the property is held, and welfare of minor who occupies the property, and the interest of any secured creditors. These factors don't form a hierarchy. The court weighs them all based on the circumstances in each case. So in cases involving family homes, court often prioritize children's welfare and the trust's purpose for providing a home. There is one crucial exception where a trustee in bankruptcy is involved. Section 335A of the Insolvency Act 1986 applies. After 1 year of bankruptcy, court must assume that the creditor's interest overweigh all other consideration unless there are exceptional circumstances. So this creates a very strong presumption of sale. Keep in mind that after 1 year, rights of creditors, they prevail over the right of occupier or the person who has gone bankrupt. Overreaching, once again, let's explain it. I thought we should explain it in detail. Last time we have touched upon it in our last session, but let's go through it. What is overreaching? And this is one of the challenging concepts. Now we come to one of the most important mechanisms in land law, overreaching. Understanding overreaching, of course, is very important. Overreaching is the process by which beneficial interests are removed from land and transferred to purchase money. Let me emphasize that the interests are not destroyed. They are simply moved from land to the money paid for the land. The statutory foundation for this is Section 2 and 27 of Law of Property Act 1925. From the purchaser's perspective, overreaching gives them clean title. When they buy land and overreaching occurs, they take free of all beneficial interests under the trust, regardless of whether they knew about those interests and regardless of whether the beneficiaries were in actual occupation. From the beneficiary's perspective, overreaching preserves their interest by transferring them to the purchase money. If the beneficiaries had 30% share in the property, they now have 30% share in the proceed held by the trustees. The mechanism solves a fundamental problem. Without overreaching, purchaser could find themselves bound by beneficial interest and those don't appear on register. Overreaching eliminates this risk. Pay to two trustees, all beneficial interests, they move from land to the money paid. That's it. Simple meaning of overreaching. So, what are requirements in overreaching? Overreaching is a mechanical process. It either works completely or it does not work at all. Whether it works depends on strict compliance with statutory requirements. Let's examine these requirements. First requirement, payment of purchase money must be made to at least two trustees or to a trust corporation. This is the most important requirement. Count the trustees who receive the money. If there is only one, overreaching fails regardless of everything else. Second requirement, there must be a valid conveyance or disposition of legal estate, not in trust. Third requirement, the transaction must be supported by valuable consideration. Gifts don't trigger overreaching because there is no purchase money. Fourth requirement, the purchaser must act in good faith. Fifth requirement, a proper receipt must be given by the trustees. If all five requirements are satisfied, overreaching occurs automatically. The beneficial interests are swept from land into the proceeds. The purchaser takes free of them, even if they had actual notice. Once again, I say it. But if any single requirement fails, most commonly because there is only one trustee, overreaching does not occur. The beneficial interests remain attached to land. Let's go to Bolin versus Flag. So, two landmark House of Lords decision illustrate how overreaching operates and demonstrates the critical importance of the two trustees, and we often struggle to differentiate between these cases, and believe me, I will make it easy for you today. So William versus Glenn's Bank Limited versus Bolland, we have talked about it before, involved a married couple. Mr. Bolland was the sole registered proprietor, but Mrs. Bolland was she contributed to the purchase and therefore had beneficial interest. Mr. Bolland later mortgaged the property to the bank without Mrs. Bolland's knowledge. When he defaulted, the bank sought possession. The crucial fact was that payment was made to only one trustee. Therefore, overreaching could not occur. Mrs. Bolland's beneficial interest remained attached to the property. She was in actual occupation, so her interest was an overriding interest binding the bank. The decision was controversial. It means lenders could take security subject to hidden beneficial interest. Now contrast. That's a different case law now. Different from the Bolland's case, City of London Building Society versus Flag. Mr. and Mrs. Flag. Now look, there are two people. Lived with their daughter and son-in-law. Once again, two people. All four contributed to buying a house, but only the daughter and son-in-law were registered proprietor. Two people. The daughter and son-in-law later mortgaged the property, and the two of them received the mortgage money as trustees. So two people received the money. Payment was made to two. The overreaching requirement was satisfied. Therefore, overreaching occurred. The Flag's beneficial interest were transferred to the mortgage money. The building society took free of their interest, even though the Flags were in actual occupation. So the contrast is struck. In Bolland, one trustees meant no overreaching and the bank was bound. In Flag, two trustees meant overreaching has occurred. The only difference was the number of trustees. That's what we need to keep in mind while we are in our LLB exam or SQE exam. Let's talk about joint tenancy and tenancy in common. Ownership is two types. Those are totally different. They operate different. And I believe there will be certain questions in your exam. So remember, this distinction exists only in equity. Legal title is always held as joint tenancy, but beneficial ownership may be held either as joint tenancy or tenancy in common. Let's examine joint tenancy first. Joint tenants own the whole property together. There are no distinct shares. No one owns half or 1/3. Joint tenants is wholly entitled to whole, like at that point. The defining feature of joint tenancy is the right of survivorship. When a joint tenant dies, their interest does not pass under their will or through intestacy. Instead, it goes automatically to surviving joint tenant. The last surviving joint tenant becomes sole owner. So that does not go to inheritance. That goes to someone who jointly owns it. This means you cannot leave your interest by will if you have a beneficial joint tenant. So your interest passes by survivorship regardless of what your will says. Joint tenancy requires 4 unities: unity of possession, unity of interest, and unity of title, and unity of time. Same possession, same interest, same title happened at the same time. Tenancy in common is fundamentally different. The tenants in common have distinct and identifiable share. One person might own 60%, other 30%, and another 10%. These shares may be equal or unequal. Crucially, there is no right of survivorship. When a tenant in common dies, their share passes under their will or through intestacy rules, or it goes to inheritance, all of it. They can leave it to whoever they want. They choose in their will or intestacy rule will choose it. This is often why people prefer tenancy in common instead of joint tenancy. Husband and wife, most of the time they use joint tenancy, and like business partners and all, they use like tenancy in common in all of it. So understanding this distinction is very important, not only for your practice but also for SQE1. So when courts must determine, like how courts decide beneficial ownership. So when courts must determine what form of beneficial co-ownership exists, they apply a hierarchy of rules. The primary rule is equity follows the law. The starting presumption is that the beneficial interest mirrors the legal title. Since legal title is always held as joint tenancy, equity presumes a beneficial joint tenancy unless there is reason to think otherwise. So presumption is joint tenancy, otherwise you need to give evidence it was not. Various circumstances rebut this presumption. Equity presumes a tenancy in common where co-owners made unequal contribution to the purchase price. One person paid 70%, other person paid 30%. Equity infers they intended to hold beneficial interest in those proportion as tenants in common. Equity also presumes tenancy in common for business or investment property when partners acquire commercial property at that point. Express words of severance in the conveyance also indicate tenancy in common. If a transfer says A and B in equal shares, at that point it is tenant in common. But here is critical point. An express declaration of trust is conclusive, where the transfer document contains an express declaration stating how the beneficial interest is held and in what share that declaration binds the parties. They cannot later argue for a different arrangement except in cases of fraud, mistake, and undue influence. Modern conveyance practices include express declaration in almost all transfer precisely because they prevent later dispute. In SQE1, always look at an express declaration first. If one exists, your analysis ends there. The declaration is determinative. So, severance. Severance, ending survivorship. Severance of joint tenancy. Severance is the process by which beneficial joint tenancy is converted into tenancy in common. Only the beneficial joint tenancy can be severed. The legal joint tenancy cannot be severed during the trustee's lifetime. Why does severance matter? Because it terminates the right of survivorship. Only severance occurs when the person who served has a distinct share that will pass under their will or intestacy. So Section 36(2) of Law of Property Act 1925 provides the most important method, written notice. A joint tenant can unilaterally sever by serving written notice on all other joint tenants. The notice does not require any particular form. The key requirements are that it is in writing and is served on all other joint tenants. Mutual agreement provides another route. If all joint tenants agree to sever, the agreement operates immediately to convert the joint tenancy into tenancy in common. Acts operating on share constitute a third method. If a joint tenant deals with their interest as if it were a distinct share, perhaps by selling it or mortgaging it to a third party, that act severs the joint tenancy. Bankruptcy automatically severs when a joint tenant becomes bankrupt. Their interest vests in the trustee in bankruptcy, and this automatically converts the joint tenancy into tenancy in common. A course of dealing showing mutual intention to sever can also affect severance. So now, what does not sever? It is important because we often wrongly think these events cause severance. Divorce or separation alone does not sever. The breakdown of a relationship does not automatically affect property rights. Making a will leaving your share to someone does not sever. A will only operates on death. So in lifetime it does not. Mere negotiation or discussion about severance does not sever. You must actually reach agreement or sever notice, or you need to sever it through notice. When severance occurs, the serving party should protect their interest by registering a Form A restriction on title. So Form A restriction on title, keep in mind in terms of severance of property rights. Exam tips. Okay, my favorite. First, always identify legal versus beneficial ownership at the start. It is the foundation. Who holds the legal title, who holds the beneficial interest. Are the same people. Never skip this step. Second, remember that legal title is always a joint tenancy. Don't waste time analyzing whether legal title might be a joint tenancy or tenancy in common. It's always a joint tenancy. Save your analysis for beneficial ownership. Third, when dealing with overreaching question, count the trustees before you do anything else. Before analyzing occupation, before considering knowledge, before discussing any other factor, count how many trustees received purchase money. Fourth, carefully separate severance from divorce and will. This is an extremely common error. Students see that parties are divorced and assume the joint tenancy is severed. Not at all. It does not. So similarly, we see that someone made a will, think that joint tenancy ended. No, it does not. Fifth, remember that matrimonial home right under the Family Law Act 1996 are not overriding interests. They must be protected by registration. The most common error we do is skipping the structural analysis and jumping straight to discussing cases. Don't do that. Always work in a system to understand what it is: co-ownership, joint tenancy, tenancy in common, and all of it. So I hope this helps you, and I wish you all the best. If you like our video, hit the subscribe button and share these videos with your friends. Ta-da!